place. As a result, was added to the 280th website. An info chart was created for victims on how to navigate the protective order process, and advocates from the original agency helping the applicant were encouraged to support the applicant through the entire process, including all the hearings. In 2021, Harris County Family Court judges changed their policy regarding where protective orders could be filed and heard. Now, if there was a prior family law case that involved the same parties, a protective order must go back to the court of continuing jurisdiction, which means the protective order had to be filed and heard in the original family court, not the 280th. As a result of this, the policies of those agencies that filed protective orders changed, which made it more difficult to get protective orders filed, heard, and granted. This also affected the number of victims the DVCC advocate and the 280th could help, because it was difficult to know when the other courts were hearing protective orders, and it was difficult to access their hearings. DVCC decided to reassign this advocate because it was a better use of our resources. This policy change also resulted in a drastic decline in the number of protective orders filed and granted in Harris County. So it seems like we're back to the same issues we faced prior to 2010. Tonight, we are here to meet and question candidates for the court of the 280th bench. We have Rose Cardenas and Diane Curvey. Ladies, welcome. Thank you. We will begin with their introductions. A coin flip has determined who would go first. Each candidate will have 3 minutes to introduce themselves, and then we'll get to questions. The candidates will take turns going first and answering the questions, with both having an opportunity to answer each question. We will conclude the evening with closing statements from each candidate. So, Ms. Cardenas won the coin toss. So.
Oh, okay, thank you.
And we have the timekeepers down front. So.
All right, thank you. Ladies and gentlemen, thank you for coming tonight. Your presence is greatly appreciated. I am a native Houstonian. I attended and graduated from Bel Air High School back in 1979, because even though I don't look it, I'm 61 years old. I'm a graduate of UT undergrad, Austin, and UT Law School, and I'm an old legal aid lawyer. I, too, at one time was a Democrat, but now I'm running as a Republican. And I was a legal aid lawyer and practiced in the Central Texas. I practiced in Bell County, Mills County, Lampasas, Coryell, Milam, Falls, San Saba, Llano, and Burnett counties for 9.5 years. I was on the board of a battered women's shelter called Families in Crisis in Killeen, Texas, during the height of Desert Storm. And the reason that I'm here is because I have been impacted by domestic violence. I grew up in a house where there was no phone because my father didn't want my mother to talk to anyone. He didn't want her to talk to her family even. The house was brown and green because his rule was the rule. When I was 26 years old and just 1 year out of law school, I was living in Central Texas in a town called Belton, and I met a woman. Her name was Lisa Marie. She was 19 years old. Her husband was 22. He murdered her. He cut her head off, he cut her arms off, and he threw her body parts in trash containers all over Austin. It was horrific, and it marked me. Throughout my legal career, I've known many women who have died at the hands of their lovers or husbands. Last year, a woman named Ashley Garcia was killed by her boyfriend when he learned that she was pregnant. So I believe that the 280th is a very important court. It is a court that can help children. It is a court that can help women. It is a court that can help families, and it provides a very important service here in Harris County.
Thank you. Ms. Curvey.
Thank you. Good evening. I'm Diane Curvey. I am the Democratic nominee for the 280th Judicial District Court, and I'm so happy to be here. Pastor August, Miss Amy, and the organization that put this together are the kindest people I've ever met, and I appreciate what they've done. I, too, am a native Houstonian, but I am a North Side girl, hanging out on the South Side with some people. You know, this is against my religion, but I'm over here anyway. I graduated from MB Smiley, and I too, I stole her speech. I too am a UT undergrad, graduated in '93, Hookham, and I was blessed to be accepted at Thurgood Marshall School of Law, where I graduated cum laude there. My career has taken me on the craziest journey ever. When you look at what I've done, which I'm going to tell you, and where I am now, you'll say, how did all that stuff match? But it all pulls together into a nice little bow, and it works. I started as a film major at UT. All I wanted to do was make film. From there, I went into social work because I began filming different social work projects, mainly adoption. And I got a chance to meet a lot of people who had backgrounds where they were unable to have children, where for whatever reason their partner did not want them to have children. We would have adoptive couples come in, and you talk with one party and they say, oh yes, we really, really want children. And then they talk with the other party separately, and the other party was saying, no, we really do not want children. And so I learned how to understand that there are three sides to every story: his side, her side, and the truth, which lies somewhere in the middle. From there, I became a teacher, and I taught school in Aldine ISD for 7 years. And that experience taught me the most. It taught me about temperament. If you have ever had a 12-year-old embarrass you in front of the entire classroom, and you understand that your car note is due, your rent is due, and you've got these other bills to pay, so you cannot choke this kid, you learn temperament, you learn how to handle things with class, and you learn how to breathe. And that's what I learned there. I understood a lot of the different families. There was a large Hispanic population there, and so I learned about the different cultures and the different strains that were put on those cultures based upon what they did in the old country. From there, I went to law school at Thurgood Marshall School of Law. I practiced law for the last 17 years, primarily in family and criminal law. This hybrid court is all about family and criminal law. There's nothing else.
We're going to start with our questions. And
Awesome.
Thank you.
Thank you.
Okay. And we're going to start with, Ms. Curvey, we're going to start with you with the answer to this question because it's kind of a follow-up to what you were just talking about.
Awesome.
Knowing that this is a specialized domestic violence court, can you please share with the audience your background and knowledge of this issue, including the number of protective orders you have filed in the past 2 years and how many went to trial? And also, how many were applicants and how many applicants did you represent and how many respondents did you represent?
Okay. So I have been doing protective orders for the past 17 years. I've had the opportunity to work under Judge Lindsay, under Judge Bradshaw Hull, and now under Judge Stalder. And throughout those years, I filed over 20 protective orders, and mostly I was representing applicants, but I also had some respondents. And the thing that I found most important is that for each side, you've got to provide them with access to the courts. As it pertains to the applicants, you've got to make certain that they have an interpreter if they need an interpreter. You've got to make certain that they are comfortable telling their story. And as it pertains to the respondent, you've got to provide access to the court to them so that they can tell their side. Because as I told you, there are always three sides to every story: his, hers, and the truth. And so I enjoyed working with both sides, but the applicant side I found it to be a lot more challenging because there were so many elements to it that that had to be explored.
Perfect.
Thank you.
Ms. Cardenas, do you want me to repeat the question, or do you?
No,
Okay.
I remember it.
Thanks.
Within the past 2 years, you said, right? I believe I've filed 5 applications for protective order. Each time for a man who's 83 years old who alleged that his wife had been violent with him. I've also represented the respondents in protective orders, and I've worked in Lynn Bradshaw Hull's court. I've worked in Judge Stalder's court. I've worked in the associate in the 257th, Angelina Gooden. Angelina Gooden's court. And all of the judges were always exceptionally attentive and open, and I found that very positive. So typically, I represent the applicant, not the respondent. And in my memory, I've done 5 within the past 2 years.
Thank you. Under what circumstances, if any, would you grant a no, sorry, Ms. Cardenas, we're going back to you now. Okay. Under what circumstances, if any, would you grant a no-contact lifetime protective order? And can lifetime protective orders be challenged? And if so, can they be dismissed, canceled, or modified?
Well, the current court has routinely signed lifetime protective orders. If there's a murder, I think it's appropriate. It all depends on the facts. My understanding is that protective orders can be modified. And I expect, if I'm elected, that I will be handling lots of modifications, because there are some people who have complained about the bevy of lifetime protective orders that have been granted recently.
Thank you. Ms. Carvey?
Lifetime protective orders come with a huge penalty to them. I cannot say that I would issue very many lifetime protective orders. And here's the reason why. With a lifetime protective order, for the rest of that person's life, you can take an 18-year-old, for instance, who has anger issues, who doesn't know how to express him or herself. For the rest of that young person's life, they will have an inability to receive financial aid, because that's a question on the financial aid form. They will have an inability to stay in the dormitories at the university, which means that they will stay at the bottom rung of the educational ladder. They will have an inability to get most jobs, because who wants to work with a person who behaves that way? They will have an inability to go to their child's school. Now, this 18-year-old, for instance, when that person grows up and they're 30 years old and they have children and a wife and a family, they moved on from whoever it is that they were stalking at 18 years old. Should we punish their children by saying, sorry, your dad will not be over the Boy Scout troop because of something he did when he was young and stupid? That's what a lifetime protective order does. It says that for the rest of your life, you're going to be punished for putting your hands on someone else. If that is the case, then the penal code needs to catch up with the protective order court and start giving out lifetime sentences for assault. The punishment has to fit the crime, and I don't believe that I'd be giving out a lot of lifetime protective orders.
Thank you. Okay. Next question goes back to you.
Yes, ma'am.
There is a national trend in the field of domestic violence, intimate partner violence, for criminal justice personnel, law enforcement, and judges to use validated risk assessment tools to understand the lethality of a case. Are you familiar with these types of tools, and what are your thoughts and views on them? Would you consider them when reviewing cases that come before you?
I would absolutely consider using those tools, because every person who finds themselves in a domestic situation is not a person who's going to be a hitter forever. You've got to look at who they are, what they've done, whether or not they have a propensity towards lifetime violence, or whether or not this was simply just a few bad incidences that went wrong. There are some people who are toxic with one another. And there are some people who enjoy that whole fighting thing. If you don't hit me, you don't love me. But it does not mean that a person is going to be a hitter forever. I think the risk assessment tools would work not only in deciding how many years of a protective order that person needs, but I think it would also help in issuing modifications for people who may have a 30-year protective order and they have them out there, or a lifetime protective order. So I would definitely use those tools.
Thank you. Ms. Cardenas?
I would also use those tools. I think it's very important to treat each case individually. And I think it's important to look at all of the facts and listen to the testimony and not make rash decisions, because a protective order can affect someone's life for the rest of their lives.
Thank you. Kind of as a follow-up question, Ms. Cardenas, we'll start with you. This is a two-part question. Will you grant the length of time that the applicant is requesting for a protective order, and or would you penalize a victim for going back to his or her abuser?
Well, the studies show that it takes about 9 times before somebody actually leaves their abuser. It is very difficult to leave an abuser. It is very dangerous to leave an abuser. So I would not punish someone for going back to their abuser. And I believe that each case should be decided individually. There are people who have a propensity for violence, and those people that case should be treated differently than a case where there was an argument and someone got slapped, for instance. There's a big difference between a gun, a knife, a push, a shove, a belt, somebody throwing a pie plate, and each case should be determined individually. If someone wants a 25-year protective order and they're 70 years old, I don't think that that's necessarily appropriate.
Great,
Right.
Thank you. Ms. Corday?
I would look at each case individually and make a determination based upon the risk assessment tools as to how many years a person would get on a protective order. I would look at the age of the person. I'd look at that person's career. I would look at this person's propensity towards violence. I would look at their court history, whether or not they have a long history of other domestic violence cases against other people, and I would go from there. The request for instance, 25 years of a protective order would not necessarily be followed unless they can show me by evidence that this person is so dangerous that you would need 25 years in order to find yourself away from them so that you will be safe. I think that the years of the protective order should be inclined to help the person who has been assaulted get into a new situation, find a new place to live, find somewhere outside that situation that they've been in. Because most people, the first thing that I said was, I'm a North Side girl. People live where they live, and they live where they're comfortable. When a person has been abused, it takes time for them to move out of the old neighborhood. It takes time for them to find new friends. It takes time for them to find a new job. And so if it's going to take them 5 years in order to get themselves together, I'm with it. If it's not going to take them, I don't understand how it would take someone 25 years in order to get themselves together, but each case would be looked at individually before I would make a determination.
Thank you. And our next question, Would you grant a protective order based on family violence if there was no physical evidence, photos, etc., assuming the witness was credible while testifying?
Absolutely. Family violence is not about bruises. A lot of family violence comes from emotional abuse, psychological abuse, stalking, and things of that nature. They don't leave outside bruises. They leave inside bruises. And unfortunately, we can't take photos of those. And so I would absolutely grant a protective order to a credible witness where there were no pictures or no bruises.
Thank you. Ms. Cardenas?
I agree with Ms. Curvey. Sometimes people don't leave bruises. Sometimes there is no evidence. Sometimes the only evidence that you have is the testimony of the applicant. So as a trier of fact, as a judge, it's important to determine whether or not the testimony is credible.
Thank you. Ms. Cardenas, it's been shown with previous judges in this court that compliance hearings made after a protective order is granted to ensure respondents are doing what they are supposed to do as a result of the order, are an effective accountability measure for survivors of violence. What are your thoughts about these hearings, and would you continue them if you are elected to the bench? And what other programs will you continue that were instituted by the existing court, including the BIP courses, parenting courses, and substance abuse evaluations?
Well, I like Judge Stalder. Judge Stalder is a true believer. Judge Stalder is the type of person who has fire in her eyes. When she hears bad facts, watch out. She is a person of very strong convictions, and I believe that she's trying to change culture. I have been a lawyer on a case where I was an amicus, and she was instrumental in changing the lives of two little girls that I know personally. So I believe in BIP classes. I believe in parenting classes. I believe that there should be compliance classes. I think compliance settings are very important because, you know, a lot of people just blow off the system. That's wrong. They just don't want to go, so they just don't go. And that's wrong because the whole idea of BIP classes is to try to teach people to know the difference between right and wrong and to learn how to cope with their emotions and make decisions that are positive for themselves and for their loved ones.
Thank you.
Thank you. For me, compliance hearings would be an absolute necessity, and here's the reason why. If this is a family with children and there's a protective order issued, I am not going to immediately order that this person have a standard possession order with these children if I believe that the children were in harm's way during that abuse. When you come in on your compliance hearings, you're going to show me that you have taken your parenting classes. You're going to show me that you're doing your substance abuse classes. You're going to show me that you're going to participate in the counseling services that my court would offer. And if you are a veteran, you are going to show me that you are participating in the veteran counseling services that I would also be open to offering. If you cannot show me those things, that says to me that you are not concerned about moving forward and having a relationship with your children. And so for as long as you're not interested in having a relationship with your children, I'm not interested in giving you a relationship with your children. Children need to be protected, and that will be job one for me.
Thank you. That, as I mentioned in our introduction about the change in the policy of the family court judges and about having the protective orders go back to the court of continuing jurisdiction. So this change caused confusion and challenges for many of the agencies who provide protective orders free of charge to survivors, and our community saw a decrease in filings. Hearing this, what are your thoughts about the change, and how do you think this change affected survivors, and what would you do to help remedy the situation?
If I may be honest, it is my belief that those cases were pulled back because there were things that were being decided that were diametrically opposed to what those district judges wanted to happen. It is my hope and my belief that if I am elected judge, that those cases will be sent back, because under the code, if I am judge, I would have the right to make some Band-Aid order decisions, and Band-Aid meaning put a Band-Aid on it until they can get back over to the court of continuing jurisdiction. But because there were lifetime protective orders and 18-year protective orders against unborn children being put out there, I don't believe that the district judges were comfortable with what was going on in the court. And I'm just being honest. It's my belief that if I am elected judge, the first thing I would do is talk with each judge personally to see what they are comfortable with and what they are not comfortable with. And if they trust me and give me back those cases, then I will make decisions based upon the level of comfort for that particular court. Because I'm not going to give someone an 18-year protective order against a small child that the district judge cannot overturn. That would be ludicrous.
Thank you. Ms. Cardenas?
Okay, so I've been a lawyer since 1986, and in the time that I've been a lawyer, I've seen the culture change tremendously. Right now, we have a judge who I like. I admire her. I think that she's done a phenomenal job. And basically, ladies and gentlemen, it is my opinion that she's been battered. She's been battered by batterers. I don't know if you know, but if you drive around downtown, sometimes you see people in pickup trucks with signs all about the 280th and about the judge in the 280th and this and that. And so this is the thing. A long time ago, when the laws were changed, I knew those people. Gail Farr and Fred Fuchs. I was a legal aid lawyer when they came up with the laws for protective orders back in the 80s. People used to get 2-year protective orders. Some judges never wanted to get protective orders at all. Now we have a judge who gives protective orders pretty regularly, and sometimes more than 2 years, sometimes lifetime protective orders. So the issue is I would contact the judges. I would go meet with them personally. I also agree with Diane Kirby. I would ask, what are you comfortable with, Judge? If they're children, or if they're children under the age of 5, would you agree to a 5-year protective order or a 10-year protective order? What are your boundaries? And then I would hope that they would trust me to use common sense and follow the law to make a decision that is rational and legal and appropriate for that family and that applicant.
Thank you. Ms. Cardenas, the 280th Protective Order Court has a very robust gun surrender program. Can you share your knowledge about this program, and is there anything you would change about it?
Okay, so the deal is that when you get a protective order against you, you're not supposed to be able to go out and buy an AK-47. You're not supposed to be able to go out and even buy a rifle. You have certain limitations on you because of the protective order. And the whole idea with the protective order is to protect. That's what the protective order is all about. So I believe that surrendering guns is a wonderful thing. And I believe that, like I said, Judge Stalder's made a lot of changes that I believe are positive, and that's one of the positive changes that she's made. Someone who has a predisposition to violence should not have a closet full or a gun safe full of guns.
Thank you. Ms. Carvey?
Can you repeat the question?
Sure. Hold on. Yeah. The 280th Protective Order Court has a very robust gun surrender program. Can you share your knowledge about this program, and is there anything you would change?
The gun surrender program is a good program. It's already in the code that you have to surrender your guns. I don't know that I would change anything about it, because I think it's important to protect those people who have been victimized. That's all I have to say about that.
Okay, thank you. What is your knowledge, Ms. Curvey, what is your knowledge of, what is your level of knowledge on the law and regarding granting protective orders involving stalking, harassment, forced prostitution, and sexual assaults?
What is my level of knowledge?
Yes.
Okay. So I've done cases like this. I've represented applicants like this. And I think that forced prostitution, stalking, and other psychological abuses are some of the worst. And if I am elected judge, I will make certain that those people receive a protective order that fits the situation that they are in. I think that it would take longer than 2 years for a 14-year-old girl to figure out how to get away from her pimp, because she's going to need a little more time. She's still young. She's still impressionable. I think it's going to take a little more time for a stalker to get it out of his system. And so I would put protective orders in place that fit the situation.
Thank you. Ms. Cardenas?
A lot of people think domestic violence is just slapping and hitting and stabbing and burning, and that's just not all of domestic violence. Domestic violence, in my opinion, is when someone loses their autonomy, when someone is under the oppression of their life partner or their boyfriend or their pimp. The legislature a couple of years ago changed the law to include stalking and other areas, the ones that you mentioned, and I think that they're very appropriate. Harris County is known for sexual trafficking. It happens every day. There are children who prostitute out of junior highs. It's crazy. And the protective order court can be instrumental in changing people's lives.
Thank you. Sometimes juveniles or the parties in a protective order suit. Do you have an opinion on one way or another about the propriety of granting a protective order against a juvenile? Do you have an age limit, if any, in mind?
Well, I think that a protective order should be able to be granted. I once represented a woman named Susie who had a relationship with a 13-year-old boy. And I suggested to the mother of the 13-year-old boy to file a protective order as an applicant for her son against Susie, who was a sexual predator. So perhaps not 9 or 10, maybe 15, 16, but yes, it is appropriate, because guess what? It happens every day. Children are victimized every day, and sometimes children are victimized by other children. So yes, I would grant a protective order for someone who's under majority.
Thank you. Ms. Curvey?
I would definitely grant protective orders against juveniles. However, I would keep in mind the compliance hearings, the rubrics that we would be using to see how they are improving in order to modify a protective order as that young person moved into the age of majority. If during those compliance hearings I see that this person is having good grades, good behavior, not abusing other humans or animals, and on their way to college, that may convince me to modify it so that they can stay in the dorms, so that they can get financial aid. Or if they have a child by that time and they need to work, based upon the compliance hearings and the tests that we would be doing on them to see how they are improving, then I would be open to modifying as they got older. But I would definitely put a protective order in place against a juvenile.
Thank you. What role do you believe judges play in regarding to prevention of domestic violence, if any?
Well, I can't speak for other judges, but as for me, I would want to begin a program in some of our areas where domestic violence is more prevalent among juveniles to start an education seminar where there would be people who would go out and teach young people, men and women, young men and young women, about what domestic violence is. Because there are a lot of young men who are suffering in silence. They're being hit, they're being kicked, they're being scratched. They don't do anything about it because they've been told you don't hit a girl. And they need protection too. And so what I would want is to institute a program where I would have people to go out, because I'm going to be on the bench. I'm going to be at work every day, working for the citizens of Harris County. But if there is some type of grant that can be procured, then I would have people out there teaching classes and teaching young people about what domestic violence is, how to avoid being in a domestic violence situation, and what to do if you find yourself in a domestic violence situation. And so to answer your question, I think that judges can play a super important part in decreasing the amount of domestic violence within the county.
Thank you. Ms. Cardenas?
It's all about education. Sometimes people grow up in homes where their parents don't have a phone because the other parent didn't want one of the parents to be able to talk to their family. Sometimes people grow up in a home where people get slapped, where people get pinched, where people get mistreated. And they don't even know that it's violence. It doesn't even register because it's their normal. So the whole idea is to change what is normal. Is it normal for a boy to slap his girlfriend? No, it should not be normal. I think it's very important to teach people what is domestic violence, to teach people what the strategies are for getting out of a battering relationship. And I think that education can be had through short films that can be shown in schools. I believe that there's money available. We just need to know how to tap into it.
Thank you. Now, the next questions are kind of, I don't want to say rapid fire, but they're going to be kind of rapid fire, but it's basically about just how you would, what your court rules would be, I guess is the best way to say that. So here's a scenario. A lawyer is representing a respondent. He or she was just hired the day before the hearing. The respondent was served more than 48 hours before the hearing. The attorney requests a reset because she was just retained yesterday. Do you give the lawyer a reset?
Is that for me?
No. Sorry.
Yes.
Yes.
Okay, good. Will you easily grant resets to respondents regardless of the code only requiring 48 hours notice?
I would.
Me too.
Okay. Will there be time limits on contested hearings for protective orders?
Yes.
I agree.
Okay.
You're still in my answer.
No, it's true. You know, in some counties you only get 45 minutes.
That's right.
Okay. No,
It's
that's
not a
good.
lot of time, but
No.
it's 45 minutes aside.
I know. It's true. Will you let witnesses testify via Zoom?
In some scenarios.
Yes, I would allow people to testify via Zoom if there was an issue with transportation, if there's an issue with age, if there's an issue because they don't live in Harris County, if there's an issue because they're deathly afraid of the alleged perpetrator, I would allow hearings through Zoom, yes.
Okay. What is your position regarding whether a victim or applicant can come back to the court and ask for a PO to be dismissed? Who wants to go first on that one?
It's all about the facts. You know, I have this idea that people don't really change their spots too much, but people can change. They can learn. They can discover new aspects of their personality. And I believe that protective orders should be modified if the circumstances are appropriate.
There is a case in Harris County where a young party had a situation. protective order was issued. The young people got back together because they had a small baby, and then they wanted to get married to one another. Under the current rules of the courts, there was not a dismissal, and there was a forcing of these young people to remain apart. You know, even though I know that a leopard doesn't change its spots, sometimes if people want a situation badly enough, you have to give it to them. If they come back, then you give them the protective order again. But if young people want to be married, in the scenario in which I'm talking about, I'm not going to stop them from being married. Who am I to tell them that they can't be married? I would definitely look into dismissing a protective order if the facts led me to believe that these young people have learned their lesson and that this is not a situation where this person is going to be murdered the next day as soon as I dismiss this protective order.
Okay, and then this is the last question before our closing statements. This has gone pretty fast. What changes do you plan on making in the court? Ms. Cardenas?
Well, I think if I were elected, I'd make sure that there was always an interpreter at the court and available at a moment's notice. Sometimes the applicants don't speak English, and even though I'm a fluent Spanish speaker, the stenographer doesn't speak Spanish, and so I'd make sure that there was always an interpreter there. I would ask that each party view the film. There's one that's on the website right now, and if I were elected, I would want to have a film created informing the parties of the effects of a protective order and the effects of domestic violence and how that domestic violence affects families. I would also not be as stringent with the current policy in the 280th about e-filing exhibits. Sometimes you don't get the exhibit until right before the hearing. And it's very important to be able to look at evidence that is admissible. And I do not believe that people should not be able to present evidence because they don't have 48 hours in which to procure it.
Thank you. Ms. Carvey?
There are 4 things that I would change in the court. The first thing that I would do is to make certain that all people have access to the courts. And what I mean by that is that I would have a designated interpreter free of charge to people who are coming in looking for a protective order. If you are a person who lives with your spouse and that spouse is the breadwinner, you don't have $150 to give to someone in order for them to interpret your testimony. You just don't have it. And so the court needs to provide an interpreter. And I would have one for Spanish, I would have one for Mandarin, I would have one for the Indian and Hindi languages, and also the Arabic languages, because there's a lot of domestic violence going on there. And if we had to set those cases up on certain days to make sure that we kept the cost down, then I would do that. The second thing that I would do is I would make certain that we have an electronic system that gets the signed orders to law enforcement agencies within 24 hours of me signing them. To have a protective order signed by a judge but not issued to law enforcement means absolutely nothing to a victim. If they don't know that this person is under a protective order, how are they supposed to protect them? The third thing that I would do is I would make certain that people who want a protective order but who are afraid to go to the courts have an opportunity to learn how to file their own protective order. And here's the reason why. If you live in a household and the other person is the breadwinner, if you put them in jail on a Thursday due to a protective order, they're going to lose their job by Monday. If If they lose their job, you're losing your house, you're losing your apartment, you're losing your vehicle, you're losing everything that you have, all because you put them in jail, and you'll have CPS in your life. And so if they learn how to do a protective order on their own, then they may be able to file their protective order, come into court, and not have CPS involvement in their case.
Okay, can you finish the fourth thing and
Yes.
your closing statement, since you go first in the closing statement, since Ms. Cardenas went first in the opening statement? Sorry.
Okay. And so the fourth thing that I would do is I would make certain that every person who comes into that courtroom, whether they are an applicant, a respondent, or an attorney, receives respect. Every person who comes in that courtroom is coming in there on their worst day. Nobody comes to protective order court because they're having a good day. You know, respect and behavior, it starts at the top. And I would be the person at the top. And I would model for my employees how they are to treat each and every person in there. And so everyone would receive respect and courtesy when they come into that court. And in my closing, thank y'all so much.
That's it?
No.
I was like, okay.
Thank y'all so much for coming out. I know that you didn't have to, but I appreciate you coming. For those of you who are watching online, thank you so much for watching. I appreciate it. I'm Diane Curvey. I'm running for judge of the 280th Judicial District Court, and I believe that I am the best person to sit in this seat because I have the temperament, I have the knowledge, and I am balanced. You must have a person who is balanced and a person who knows how not to go off the deep end because they hear facts. Their eyes should not light up. They should not be on fire because they hear facts. They should be balanced, and they should be able to work with both sides in a respectful manner and be able to deliver justice fairly. Thank you all for coming out.
Thank you. Ms. Cardenas.
Ladies and gentlemen, thank you very much for coming. It's really appreciated. I'm a lifelong Houstonian. I've handled thousands of cases since 1986. I've handled probably 100 or more protective orders. I have two brothers. I'm a Latina. I didn't learn to speak English until second grade. And my whole thing is, as Ms. Kirby said, it's all about respect. And if I'm elected, it will also be all about rational decision-making and a temperate listening to the facts before making a decision, and honoring the people that apply and present themselves in the 280th, because, as Ms. Carvey said, that's usually their worst day. Thank you for coming out.
On behalf of the Domestic Violence Coordinating Council, our community partners that are in the audience, and our community members that are in the audience, thank you both so much for agreeing to do this. I know that when we first reached out, you both jumped in right away. You were both excited about doing this. And I would like to say, as the moderator, I appreciate the respect that y'all have shown each other, because we've had debates where that was not a case. So we appreciate the fact that y'all both agreed to do this, and you both agreed to come. So thank you both very much. I think the 280th is going to be in some good hands coming in January, and we'll be there rooting you on and working for whoever's elected. So thank you all so much, and thank you all for everyone for coming. We got out a little bit, just a smidge early, but I think we got all the questions to take care of. So thank you all very much, and thanks. Be safe out there, support each other, and y'all take care. Thank you.
Thank you.
Thank you.
Thank you so much. I appreciate it. Thank you so much. Thank you.
Thank you. Thank you.
Thank you, Annie.
You know I love you.
I love you back.
We love each other.
I know. Oh, do you want a picture?
Oh, yes, ma'am.